The broadcast is now starting. All attendees are in listen-only mode.
Good evening, friends, and welcome in this special webinar for the Supreme Court judgment under Section 148 of the IT Act. We are grateful to our speaker, CA Naveen Khariwal ji. We are very thankful to you, sir, you giving your precious time, your experience, and sharing your knowledge with all of us. We are special thanks to CA Rajesh Mehta, sir, who is our guide, who is our motivator, who is our inspirational, who is already always available for us, who is a wealth of knowledge, and sir is continuously taking session as well across India. Sir is from Indore, but everyone, every professional across India is known to sir. I mean, sir is now taking session on the coming Saturday at Jaipur also. On multiple forums, sir is also available.
Your voice is not coming. Viragji, your voice is not coming. Voice is lost. Voice is not coming. Virag bhai, your voice is not coming.
Virag bhai, you're not audible.
So till Virag bhai again reconnect, I would thank our today's speaker, CA Naveen Khariwal ji from Bengaluru. He is a renowned speaker across India on various important topics of direct access since so many years, and I have listened him so many times, and I am very much influenced by his thorough knowledge and influential and very clarity of the knowledge on every topic of direct access. And today the burning topic is Supreme Court judgment with respect to Section 148 and 148A of the Act. This was during last 1 year, everyone was very much happy that all the 148 notices are going to become invalid. However, Honorable Supreme Court had given the judgment that notices are not invalid, but they had given, Honorable Supreme Court had told on the 4th May 2022 that CBDT will, all the officers are free to issue the notices in view of the prevailing Section 149 of the Act. So, however, the Supreme Court had given the view that the notices will not become invalid, but in view of the judgment, in view of the provisions of Section 149 of the Act, this is a welcome judgment from the angle of the taxpayers also, because many of the notices issued for any year prior to assessment year 2018-19 would become invalid in my opinion. However, we are having the very renowned speaker. He will enlighten us on this, all the intricacies of the CBDT instruction number 01/2022 and the judgment of Honorable Supreme Court, and what are the provisions, and what are the provisions if the income is more than 50 lakh, and whether this 50 lakh is per year or aggregate, because the CBDT has stated that the Finance Act 2021 provisions will be applicable. In the Finance Act 2021, the 50 lakh limit was per year, and in the Finance Act 2022, this limit has become 50 lakh rupees aggregate for all the years. And as regards more than 50 lakh, even I am of the opinion, even if it is more than 50 lakh per year, more than 50 lakh aggregate for every year, even though in my opinions, Income Tax Department cannot issue any notice for any year prior to assessment year 2018 and 19, because they must have some books of account in their possession, document in possession, or any evidence in possession. In my opinion, such evidence, such books of account, evidence or document can be in their possession only by way of search or survey, none else. Because anything what they are having, that may be only the information in possession, because they are having AIR information, annual information statement, statement of financial transaction, or 26S. These all are the information, or they may also be having any TP. So these all are the information, because there is not evidence obtained by themselves. The department has not done any efforts to obtain those evidences. So if any of the evidence, so in future also there will be a lot of litigation on the basis of this more than 50 lakh limit, how they can be said to have information in possession, how they can be said to have books of account, evidence or document in possession. What is the definition of evidence, what is the definition of document, and whether it can be photocopy, whether it can be original. In my opinion, any photocopy of document, any photocopy of any evidence will not be suffice to issue any 148 notices. All the document in original or evidence in original can only be the sufficient to issue any 148 notice. Or the books of account as defined under section 2 in the Income Tax Act, any document as defined under section 2 in the Income Tax Act will also have to be looked into while challenging any 148 notices in future. So, and the CBDT instruction 01/2022 itself is going to create so many litigation. So many of the writ petitions may also have to be filed after 2nd June 2022. CBDT instruction has told that the notices can be issued up to 2nd June 2022. However, that date itself is the 3rd June 2022. However, there is no problem of one day. But if the judgment of Honorable Supreme Court has came on the 4th May 2022, then the period of 30 days expires on the 3rd June 2022. So they have also missed one day. But this is beneficial for the taxpayer. So this is also welcome. And this is only my brief opening remark. So we will listen to Naveen ji, who is expert, and he will enlighten us, and very much the confusion regarding 148, 148A, 149. So these all things will be cleared in today's deliberation by respected Naveen ji. And now I again hand over mic to our Virag bhai. Virag bhai is a very energetic, vibrant person. He is doing various webinars on his platform Connect Easy. All the important topics I am very much in connect with him since so many years. He is very energetic chartered accountant from Mumbai. He always organizes various webinars and of important topics for the taxpayers, tax professionals, chartered accountants, and various renowned professionals, various renowned ministers have joined, came on his platform. And once our Honorable Finance Minister Nirmala Sitharamanji's program was also organized with the help of Virag bhai. His platform was used by us, FTP. So we are thankful to Virag bhai for organizing webinars regularly for tax professionals. I hand over mic to Virag ji for further proceedings.
Thank you so much, Rajesh Mehta sir. You are inspirational for us. You are guiding factor for us. Always inspiring and always supporting to us. We are very thankful to you. Your today's brief welcome note on the issues and controversies in Supreme Court is very apt and to the point, sir. Thank you once again for addressing the attendees. Now would like to welcome CA Naveen Khariwal sir, a renowned tax expert on direct tax, a speaker on various forums. Sir is continuously speaking from last so many years on various issues on taxation. On this topic also, sir has many sessions already had taken at 1 or 2 sessions in the past, and also session continuously across India on this virtual mode. Also, sir has a session on Saturday also, and many other days on similar kind of topics. So, sir is very known personality to all the professionals. So now, without wasting much time, would like to welcome CA Naveen Khariwal sir and request sir to take the proceeding ahead for our today's session. Over to you, sir.
Thank you, Rajesh bhai, and thank you, Virag bhai. Founder Connect Easy. So let me just begin my presentation. Yes, sir. So I think we have chartered accountants and as well as businessmen who have joined from all over India. So I would like to proceed in this fashion. Sometime I would like to spare for the old provisions of 147, then come to Finance Act 21, then go to Finance Act 22. Thereon we move on to the Supreme Court judgment delivered on 4th of May. And thereafter we analyze the Supreme Court judgment, come back to the instruction issued on the 11th of May. And then we'll analyze the board instruction. Then go into delve into the numerous issues and controversies. And then, spare some time for Article 142 and also of the Constitution. And at the end, we can take some questions if there be any. What I would like to tell members at the beginning itself, these are all whatever I would be discussing are all my personal views. And these views are to be tested in a court of law. They are not yet tested in a court of law. So these are all my personal views based on my research, my interpretation, my understanding of the topic. So let us just begin. So before this Finance Act 21 and also Finance Act 21, what is the concept of the scheme of reassessment? Members, if you see, there are sections 147, which is assessment of income escaping assessment. 148 is issue of notice where income has escaped assessment. Then Finance Act 21, this 148A is inserted. Conducting inquiry, providing opportunity before issue of notice under 148. 148AB is prior approval for assessment, reassessment or recomputation. 149 is the time limit. 151 is sanction for issue of notice. 151 capital A is faceless assessment of income escaping assessment. How far is it faceless? I would not know, because they can definitely see us. We are not able to see them actually. It is one-way faceless, one-way traffic. 153 is the time limit for completion of assessment or reassessment. 135 is faceless collection of information. So this 147, we come to this is Finance Act 21. So before this, members, around about 60 plus years, the word reason to believe was there in the act or reassessment. Reason to believe, I would not like to go into the old case laws. Stood the test of time for more than 60 years, except for 2 years in the intervening period between 87 to 89, when the words reason to believe are not there in the statute. But if you see, a lot of Supreme Court judgments, a lot of jurisprudence, you have a lot of runs and runs of material. Like how FBT was there. With erstwhile, when P. Chidambaram was the finance minister, introduced FBT. People do not pay tax on income. The erstwhile finance minister introduced tax on expenditure, fringe benefit tax. So one fine day, they came and they abolished and they removed FBT from the statute. So like this now, runs and runs of material, a lot of case laws at Supreme Court level, High Court level, tribunal level, etc. You have, numerous judgments. Now the word reason to believe, my dear friends, is substituted with information suggesting that income has escaped assessment. Reason to believe consigned to the fate of history, replaced by the word information suggesting that income has escaped assessment. Now see the 147 section as amended, altered by Finance Act 21. If any income chargeable to tax has escaped assessment, the assessing officer, subject to the provisions of 148 to 153, he can assess, reassess, recompute the loss or depreciation allowance or any other allowance or deduction. Very, very simple. They have tried to simplify the section. So income, defined in 2 within bracket 24. Tax is defined in 2 within bracket 43. Assessment, you know, regular assessment means under 2 within bracket 40A, an assessment under 143(3) or 144, or assessment under 2 within bracket 8 of the Act says assessment includes reassessment. Assessing officer, you know, are defined in 2 within bracket 7A. So 147 is telling it is subject to provisions of 148 to 153. So 147 is, you know, passing of order. You pass the order subject to following the provisions of 148 to 153. I'm not quite happy with the, you know, the sections. The 147 says order. Then 148A. 148 says notice. 148A says, you know, conducting inquiry, etc. Then 149 says time limit. 151 will say sanction. It should be other way around. First 151 should come. First to take the sanction, then see the time limit, etc. Then take the approval, and then see the time limit, and then within the time limit give an opportunity of being heard to the assessee, and then, you know, come to then pass the order 147. Anyway, this is how the Act, the sections are placed in the Act. So 147, very simple section. It says income chargeable to tax has escaped assessment. The assessing officer wants to reopen it. He's telling, hey, assessing officer, please follow 148 to 153, and you can reopen the case. There is a small explanation. It says, for the purposes of assessment or reassessment under this section, the assessing officer may assess or reassess income in respect of any issue which has escaped assessment, and such issue comes to his notice subsequently in the course of proceedings under this section, irrespective of the fact that the provisions of section 148A have not been complied with. Very, very simple, sir. Take for example, Mr. Biresh has got a bank account, has got an FD in Bangalore and FD in Indore. So Indore FD, he has not offered to tax, he has not declared in the return, he has not offered that interest. But now you know 148 is subject to 148A. Before issuing notice under 148, the new provision says, look here, assessing officer, follow the dictum of 148A. There are 4 clauses, 148.8A, conduct inquiry, 148.8B, 148.8AB. It says, give show cause to the assessee. C says, 148A, C says, take the, give opportunity to the assessee of being heard. And D says, consider the reply of the assessee and material available on record, then pass an order under 148A clause D, saying that whether it's a fit case for reopening or not, whether it's a fit case for assessment or not. So 148.8A, see the wording starts with assessing officer shall. Then it says 148A says conduct inquiry if required. We'll come to that when we come to 148A. If required. B says, you know, show cause notice to the assessee. C will tell consider the given opportunity of assessee being heard. D will say consider the reply of the assessee, and based on material available on record, please pass an order on 148AD saying whether it's a fit case for assessment or not a fit case for assessment. Along with the order, attach the notice under 148. Again, the notice shall be issued, issue versus service. Supreme Court. R.K. Upadhyay versus Shenabhai Patel, Supreme Court judgment is there. 148, we have to see the issue versus service. So then they are telling issue 148 along with the order passed under 148A clause D. Now come back, we are in 147. Whole idea is Mr. Biresh had an FD at Indore and he had an FD at Bangalore. So 148A, now information suggesting income and escaped assessment. Assessing officers telling, yes, FD at Bangalore had escaped assessment. But in the course of the reassessment proceedings, they also came to know now because PAN, bank, Aadhaar, everything is linked. They came to know that Mr. Biresh had an FD at Indore, which he did not offer to tax. So therefore, what is the explanation telling? Any issue which has escaped assessment and such issue comes to his notice subsequently in the course of proceedings. In the course of proceedings means it is still in progress. It has not ended. Order is not passed. Irrespective of the fact that the provisions of 148A have not been complied with. Naturally, 148A, I just wrote information suggesting escapement of income for the FD at Bangalore, not at Indore. Now, move forward 148. So 148, they are telling before making, you know, the assessment or recomputation at 147 and subject to provisions of 148A. We discussed. Before you issue notice under 148, it's subject to the section 148A. Follow the procedure. Then the assessing officer shall serve on the assessee a notice along with a copy of order passed if required under 148 AD. Then he's telling you furnish your return of income. I'll give you the time in the prescribed manner, setting forth such a particular within the time limit specified in the notice. Also, they are telling return of income or the income of any other person in respect of which he is assessable under this act during the previous year. It may be, as a legal error, or it may be, for example, minor's income under 64(1)(a), representative associate, etc. And very interestingly, it says, so far as may be provisions of this act, so far as may be apply accordingly as if such return were written required to be furnished under 139. Now see the provisos. Proviso to 148. First proviso is telling no notice shall be issued unless there is information with the assessing officer suggesting that income has escaped assessment and the assessing officer has obtained prior approval of the specified authority. Who is the specified authority? Come to 151. There are only two types of specified authority now. Up to 3 years, time limit now, up to 3 years, beyond 3 years, up to 10 years. So I have to take approval of the specified authority. There are only two types of specified authority, beyond 3 years, up to 10 years. Take the approval of PCCIT, Principal Chief Commissioner of Income Tax. And then up to 3 years, they are telling take the permission of Principal Commissioner of Income Tax. If there is no Principal Commissioner of Income Tax, it is Chief Commissioner of Income Tax or Commissioner of Income Tax. Now, second proviso is telling, provided further that no such approval shall be required where the assessing officer with the prior approval of specified authority has passed an order under clause D of 148A to the effect that it's a fit case to issue notice under this section. So this we are discussing Finance Act 22. Finance Act 22 this is. So this, amendment has come in Finance Act 22. What are they telling? They are telling, see, in that 148A, B, C, D, every stage you have to take approval. Every stage they are telling, please take approval from the specified authority. So they are telling, when you passed order 148AD, you took the approval, then only you passed. What do you mean by 148AD? That means it's a fit case for approval. I mean, it's a fit case for reopening. So therefore, you are going to issue notice under 148. So you did not take further approval to issue again notice under 148. You took approval for passing order 148AD. What is the next step? You just need to attach a notice under 148. For that also, there was approval by Finance Act 21, which approval has been taken away by the statute from Finance Act 2022. So they are telling there is no need of any approval assessing officer. You have already taken the approval up to the stage of passing of order 148AD. Therefore, now you cannot raise that point. Sir, that for issuing 148 notice, you have not taken approval. Not required, sir. Second proviso is forbidding the assessing officer. Now, very interesting explanations, Finance Act 22. I am connecting Finance Act 21 also, don't worry. So earlier in the Finance Act 21, there was only two types of information. I told you when you can reopen, sir, there should be information in possession of assessing officer that income chargeable to tax has escaped assessment. That is information suggesting income has escaped assessment. What were the types of information? Only two types of information by Finance Act 21. It was any information flagged in the case of assessee for the relevant year in accordance with RMS strategy formulated by board from time to time. Second one was final objection raised by Comptroller and Auditor General of India to the effect that the assessment in the case of assessee for the relevant year has not been made in accordance with the provisions of this act. So those two only were there by Finance Act 21. Then there was an amendment in the Section 1 in Finance Act 22. The word flag has been deleted, removed in the statute. So what it says, only information in accordance with risk management strategy formulated by board from time to time. File objection, you ask what is risk management strategy? You are formulated by board. Come on, give me copy of risk management strategy formulated by board. You cannot do an assessment behind the back of the SSA. Every stage you'll have to file objection. Please ask for RMS strategy formulated by board. Then they are telling now it has become more dangerous. What was final objection raised by C&AG? They have removed the word final objection raised by C&AG in Finance Act 22. What is therefore remains? They say any audit. They say any audit objection to the effect that assessment has not been made in accordance with provisions of this act. So left, right, and center, they can reopen the case. Any audit objection. Take for example, 234 ABC not calculated correctly. For example, chapter 6A, you are not claimed correctly. For example, 80 IA 10, you did not claim correctly. Whatever. Any audit objection they are telling. Then there are three more. What was two information earlier? Two types of information, two limbs. There are now 5 limbs. These two you understood. Third limb is what? Information received under your DTA, 9090, etc. Fourth one says information available to the assessing officer under the scheme notified at 135A. That is your faceless collection of information, faceless scheme of assessment. Then any information which requires action in consequence of an order of a tribunal or a court. Then this becomes an information suggesting that income has escaped assessment. There are 5 types of information. Now, see explanation 2. So what was explanation 1? They gave meaning of information, direct meaning, 5 types of information. No problem, sir. What is explanation 2? Explanation 2 is nothing but deemed information. What is the difference? We'll come to it, don't worry. Explanation 1 is meaning of information. There are 5 types of information. Absolutely no doubt about it. Next, explanation 2 is deemed information. Now they are telling what is the deemed information. We will go through. So search is initiated at 132 or books of accounts or documents or assets requisitioned 132A. Obviously, it's on or after 1st day of April 21, or a survey is conducted at 133A other than subsection 2A. What is subsection 2A, my dear friends? TDS survey, TCS survey. What is subsection 5? It was there in Finance Act 21. They deleted it in Finance Act 22. What is subsection 5? Supreme Court is saying Finance Act 21 only. What is Finance Act 22? This subsection 5 deleted. Ceremonial survey. Your marriages, functions, etc. So now they are telling survey conducted at 133A other than subsection 2A. That means other than TDS TCS survey. In any case, subsection 5 is removed from the statute. Same thing on or after 1st of April 21. Number 3. The assessing officer is satisfied with prior approval of principal commissioner or commissioner, money, bullion, jewelry, valuable article, thing seized or requisition 132, 132A. In the case of other person, in the case of any other person belongs to the assessee. This is like your earlier 153C regime, my dear friends. 153C. Same thing if you see 4. Again, assessing officer satisfied prior approval of principal commissioner, books of accounts or documents seized or requisition. In 3, you have what? Money, bullion, jewelry, valuable article or thing seized or requisition. In 4, this telling books of accounts or documents seized or requisition. Both are same. This is only for 153C type cases in the erstwhile search regime. It pertain to or any information contained therein relate to the assessee. So these are the 4 types of deemed information. Now they say, then the assessing officer shall be deemed to have information when, suppose there is a search under 132, books of accounts, document, assets, requisition 132A, survey conducted 133A, then the money, bullion, jewelry, valuable article or books of accounts, documents, etc. seized. So all this will enable the assessing officer to have deemed to have information which suggests the income chargeable tax escaped assessment. In case of assessee, where the search is initiated or books of accounts or documents or assets are requisition or survey is conducted in case of assessee or money, bullion, jewelry or other valuable article or thing or books of account or documents are seized or requisition case of any other person. Very, very simple. So this is the meaning of deemed information. We'll discuss further when we come to the other section. Specified authority. Now explanation 3. For the purpose of this section, specified authority means the specified authority referred to in 151. So very simple, sir. 148. This is 148. You issue the notice. Along with the notice, attach copy of order passed on 148 AD. Thereafter, they are telling you cannot issue unless there is information in possession of assessing officer suggesting the income has escaped assessment. You should obtain prior approval of the specified authority. And further, for 148 AD, once you are taken approval for 148 AD, it is not required again approval to issue notice under 148. Explanation 1 is giving meaning of information, 5 types of information. Explanation 2 is giving meaning of deemed information, 4 types of deemed information. We move further. 148A. So 148A was newly introduced by Finance Act 21. The statute, the Union of Government of India gave respect to the judgment law in GK and drive shaft. 259 ITR page 19. What was the erstwhile regime, my dear friends, in 147? 148 used to come. You people used to file return, upload the return under section 148 in response to the notice received, declaring same income what you declared under 139(1). Thereafter, you are writing a letter to the assessing officer, attaching copy of acknowledgement, and please asking them, sir, please give me copy of reasons recorded. Also give me copy of approval if any received by the principal commissioner of income tax, section 151. Thereafter, the assessing officer used to give you that reasons recorded. Thereafter, you used to file, that is only after you would have uploaded the return. Thereafter, you would have, filed your objections for reasons recorded, and the assessing officer would dispose of that reasons recorded as if it was an order by separate speaking order, disposal of objections. Separate order was passed. Against that, what you have to do? Only writ was available. You could not have filed an appeal under 246A with the first CID appeals. That was a judgment law. There was no such section in the erstwhile regime of 147 scheme of reassessment. It was a judgment law. Now the department giving respect, now the Union of India, Finance Ministry, the statute giving respect to the judgment law has incorporated those provisions in the form of a new section under 148 capital A. Now they are telling, look here, Mr. Assessing Officer shall, before issuing any notice, conduct inquiry A, if required, they say, with the prior approval specified authority, with respect to information which suggests that income chargeable to tax escaped assessment. Then B says, I told you, provide opportunity of being heard to the assessee by serving show cause. What is 148A, B, sir? What is the time limit now? As per the Act, minimum time should be 7 days. Maximum time to be 30 days. Also, on an application filed by the assessee, he could also request for an extension. Okay. And then consider the reply of the assessee C. Then D says, on the basis of material available on record, including reply, you please decide whether or not it's a fit case to issue notice under 148 by passing an order. Suppose no reply is received by the assessee. Now I told you, Mr. Viresh, who took that example. So that fellow did not reply at all. No problem. Within 1 month from the end of the month in which the time or extended time allowed is expires, that's all. So they will pass the order. So now the question therefore happens is, what do you mean here by assessing officer shall? Here it says shall. Understand very carefully. Assessing officer shall, before issuing any notice, ABCD, but conduct any inquiry if required. Now I can only give you my opinion. This is, according to me, 148A, conduct any inquiry is mandatory, compulsory for all non-search, non-survey, all non-search and non-survey, non-requisition cases. For all that, you need not conduct any inquiry. But when you should conduct inquiry? For all other than such cases, other than survey cases. Why? I will tell you why. My logic. So 148A, B, C, D. Now, proviso says now 148A, provided where the provisions of this section shall not apply in a case. Proviso is telling these provisions shall not apply to where search is initiated. So it's telling no question of giving you time now. 148 ABCD, no question of following that procedure, conducting an inquiry, etc., issuing show cause notice, because this deemed information. We discussed there 4 types of deemed information. So here, where is the question of doing any inquiry? So search, that's why he's telling conduct any inquiry if required. So here it is not required here. Why? Law provides itself telling shall not apply in a case where search is initiated at 132 or books of accounts document requisition or money, bullion, jewelry, valuable article, things searched in search under 132 or 132A, or again books of accounts or documents issued, or any information under scheme notified on 135A. So in all these 4 cases, they are telling assessing officer need not follow the procedure of 148A, clause A, B, C, D information. That means he has to follow in other than these cases. That is why they say with required. So that is my analysis, that is my interpretation. If required. So in these cases, not required. In other cases, it is required. Anyway, then they are telling this insertion of new section 148B. This is a small section, they are telling no order of assessment or reassessment is there in Finance Act 22. Assessment or reassessment or recomputation shall be passed by assessing officer below the rank of Joint Commissioner. Okay, in respect of an assessment here to which clause 1 or clause 2, clause 3, clause for explanation 2 to section 148 apply except with the prior approval of additional commissioner, additional director, joint commissioner or joint director. Explanation 2 to section 148. This is what is the explanation 2. Where is that? Yeah, this is explanation 2, where the search, survey, etc. Now moving further, that was Finance Act 22. Now section 149, very, very important section. So my dear friends, earlier regime 147, I am going pre-Finance Act 22. Sorry, 21. Pre-Finance Act 21. That means Finance Act 20, Finance Act 21, Finance Act 22. So earlier, what was the time limit, my dear friends? Up to 4 years. Beyond 4 years, up to 6 years. If the income which was escaping assessment was at least amounted to 1 lakh rupees or more. Okay, beyond 4 years, up to 6 years. And also beyond 6 years, up to 16 years in case of a resident in India having any income from asset abroad. So that was 16 years. Now that is pushed to Black Money Act. So this period now in the new regime, it is now what was 4 years has now become 3 years. Up to 4 years, beyond 4 years, up to 6 years, beyond 6 years, up to 16 years. Earlier, beyond 4 years, up to 6 years, when not fully disclosed truly and fully all material particulars. And any assessment was already made 143.3 or under this section they used to tell. Indirectly they used to tell 144. So any order passed on 144, 147, 143.3 when it could have been reopened. Okay, and then beyond 4 years up to 6 years, unless the income chargeable tax escaped assessment amounts are likely to 1 lakh rupees or more. In the new act, they have reduced the time limit, Finance Act 21, up to 3 years. 4 years became only up to 3 years. Then 3 years, but not more than 10 years, unless the assessing officer has in his possession books of accounts or documents or evidence which reveal that the income chargeable to tax represented in the form of asset which has escaped assessment amounts to or likely to amount to 50 lakh rupees or more for that year. Very clear, sir. Finance Act 21. So up to 3 years, beyond 3 years, up to 10 years. When can I go beyond 3 years, up to 10 years? Finance Act 21. Assessing officer should have in his possession books of accounts or documents or evidence. 3 things he should have in his possession: books, documents, evidence, which will reveal that the income which has escaped assessment is represented in the form of asset which has escaped assessment, which is amount to or likely to amount to 50 lakh rupees or more for that year. Now, this Finance Act 21, these are the provisos. There are, 4 provisos. So, provided no notice under 148 on or before 1st of April shall be issued at any time in a case for relevant assessment year, beginning on or before 1st of April 21, if such notice could not have been issued at that time on account of being beyond the time limit specified under provisions of clause B of subsection 1 of the section, as they stood immediately before commencement of Finance Act 21. Understand carefully. This is the basis for Supreme Court judgment. This is the basis for board instruction. What is first proviso? It is crystal clear, sir. Provided no notice 148 shall be issued at any time, beginning on or before 1st day of April 21. So 1st day of April 21, okay? If such notice could not have been issued at that time, what is at that time? What do you mean by at that time? On account of being beyond the time limit specified under provisions of clause B of subsection 1 of this section 149, as they should immediately before the commencement. That means the old provision 149. What is that provisions of clause B? Beyond 4 years up to 6 years. So that old provision clause B of subsection 1 is up to 6 years from the end of assessment year. So law is telling what you could not have done then, also you could not do now. That is why, see, Finance Act 21, law is passed on 28th of March 21. So from there, up to 31st March 21, for which year I could issue, sir? 6 years from the end of assessment year. Old provision of 149. Yes, they are clearly telling up to 4 years, beyond 4 years, up to 6 years. So up to 6 years from the end of assessment year. 13-14, it is March 20. 14-15, it is March 21. 15-16, it is March 22. So this is the amendment is in April 21. 1st April 21, there is an amendment. So they are telling very simple, what you could not have issued then also cannot be done now. We will come to the controversies and issues as we go by. So this is the first proviso. Second proviso says the provisions of section shall not apply in a case where notice on 153A, C read with 153A required to be issued in relation to search under 132 books of accounts, etc. on or before 31st day of March 21. Sir, before 31st March 21, search provisions were there, 153 ABC were there. So that's what it's telling. Only after 31st March 21, from 1st of April 21, the new provisions would apply. Earlier it was 153 ABC only prior to 31st March 21, no problem. Third provision also is telling, for computing the period of limitation as per this section, that 3 years or 10 years, etc. Time or extended time allowed to the assessee as per show cause notice under clause B of 148A. So 148A clause B, minimum 7 days, maximum 30 days, etc. Or period during which the proceeding under 148 is stayed by an order or injunction if you have filed a writ, that period shall be excluded when you are issuing the notice. So this period shall be excluded. Assessing officer will get that much extra time. Fourth proviso, provided also where immediately after the exclusion of the period referred to in the immediately preceding proviso, period of limitation available to the assessing officer for passing an order on 148 AD is less than 7 days, then such remaining period shall be extended to 7 days and the period of limitation shall be deemed to be extended accordingly. Then explanation, they gave the meaning of asset. Finance Act 21 only we are reading. Very important because Supreme Court is reading Finance Act 21. Now they are defining asset. They are telling asset shall include immovable property being land or building. Don't you know, sir? Don't you know the meaning that land and building is an asset only? Or both, or shares and securities. Don't we know shares and securities an asset? Loans and advances. Don't you know loans and advances is an asset? Deposits in bank account. Deposits in bank account is an asset. Don't you know? You know it. Where was it necessary for them to define the word asset? So we don't know whether it was a case of benevolence on behalf of revenue or the revenue shot itself in the foot. Anyway, they defined the word asset. Finance Act 21 shall include only 4 types of assets: immovable property, shares and securities, loans and advances, deposits in bank. Nothing else. Then, as usual, provisions of subsection 1 as to issue of notice shall be subject to provisions of 151. Now this 149 from Finance Act 22, if you see this 149 Finance Act 22, they are telling 3 years have elapsed from the end of relevant assessment year unless case falls under B. 3 years, not more than 10 years, unless the assessing officer has in his possession books of account, document or evidence which reveal that income chargeable tax escaped in the form of, they came to their mistake, Finance Act 21. But Supreme Court judgment is telling only Finance Act 21, only meaning of asset, 4 items. Now they are telling other than asset. They say asset, expenditure in relation to a transaction or in relation to event or occasion, entry or entries in books of account. Now 3 things they are telling. If it reveals income chargeable tax escaping assessment beyond 3 years up to 10 years, that 250 lakhs, as Rajesh Bhai rightly pointed out, earlier it was per annum. Now it is in aggregate beyond 3 years up to 10 years. 50 lakhs will be in aggregate. And what all to see? In what form should be that undisclosed, escaped, concealed income? It should be either in form of an asset or expenditure in respect of transaction or relation or entry or entries in books of account. What entry? It may be journal entry, it may be debit entry, it may be credit entry. Any entry assessing officer does not exist and hey, this is escaped income. Asset, anyway, they give 4 types of asset. Beyond that, they are telling there is no other asset, only 4 types of asset. So expenditure in respect of a transaction in relation to an event. Now entry or entries in books, you are doomed now. Any entry in the books of accounts, take that, becomes information. Anyway, move forward. So this is what is the first proviso, very, very important. Provided no notice and 148 shall be issued at any time in case for relevant assessment year beginning on or before 1st day of April 21. If a notice, etc., could not have been issued at that time on account of being beyond the time limit, as they should immediately before the commencement of Finance Act 21. You will see examples when you come. All this we saw, sir, same thing, nothing to worry. Move forward. 149(1)(a). 149(1)(a), now they are telling, income chargeable tax represent form of asset or expenditure. He's not talking about book entry. He's not talking about entry in books of accounts here. As escaped assessment, investment in such asset or expenditure has been incurred in more than one previous year relevant to the assessment year within the period, then a notice and 148 shall be issued for every such assessment year. Section 151 is specified authority. Moving further. Now, 135 is faceless collection of information. Come to your, now there is this this board circular. Why I took this board circular 10/12/21, my dear friends? This is on Insight portal, implementation of risk management strategy for issue of notice under 148. So here if you see this RMS strategy formulated by board, they are themselves giving the meaning, and this clearly assessing officer, what they have told, this was before March 22, because March 22, a lot of notices came for 18-19 and 15-16. Why? 15-16, 6 years from the end of relevant assessment year. March 22 was getting over, sir. March 22, and 18-19 up to 3 years from the end of assessment year, that is March 22 again. So therefore department, they were in a hurry to issue notices for 15-16 and 18-19 before March 22. These are all information there on Insight portal. But I am more interested in para 5. In para 5, the board instruction, they themselves are telling, as per provisions of 149(1) being specific cases where assessing officer and his possession evidence which reveal that income escaping assessment represent form of asset amounts to or likely to amount to 50 lakhs or more, notice can be issued beyond period of 3 years, not beyond period of 10 years. Fine. But it comes with a rider, first proviso. Further, notice under 148 cannot be issued at any time in a case for relevant year beginning on or before 1st day of April 21. If such notice could not have been issued at that time on account of being beyond the time limit prescribed under provisions of clause B, as they stood immediately before the proposed assessment, 6 years it was, which became 3 years again then. 3 years and up to 10 years. Earlier it was up to 6 years. And meaning of asset they are giving. We will see again. In view of the above, this board circular itself, they are telling, directed that information pertaining to assessment year 15-16, which requires action 148, shall be identified, uploaded on the VRU functionality on Insight portal under 149 1B. So the department is not discussing anything about 13-14 or 14-15. They themselves are telling only take care of 15-16 and 18-19. Why 15-16 6 years ends at March 22, 18-19 3 years to end on March 22. So just bother about these two. They are not telling anything about 13-14, 14-15. Anyway, so we move on further. Now this is the Supreme Court judgment. So what has happened? What is the background for the Supreme Court judgment? 20th of March 20, COVID struck India and COVID struck the world, and COVID was for you, COVID was for me, COVID is for the SSC. So what happened? 20th March, they brought in what is called as TOLA. You brought in TOLA, very good, for 13-14. For 20th March, standing on 20th March 20, up to March 20, 13-14, 6 years from the end of relevant assessment year. But you brought in the TOLA as on 20th March, you want to extend the due date because of COVID. Fair enough. But for 5 years, 11 months, 20 days, assessing officers kept quiet. They did not issue a single notice for escapement of income for assessment year 13-14, 6 years from the end of assessment year, March 20. 20th March, COVID struck, TOLA came in. So for 5 years, 11 months, 20 days, all of you kept quiet, all assessing officers, you did not issue a single notice. Just for 10 days delay from 20th March to 31st March, for 10 days delay, time is extended up to 30th of June 21. 1.5 years extension, you have got time to only issue notice. Time limits for what? Under the erstwhile regime, 6 years from the end of assessment year. For 5 years, 11 months, 20 days, you kept quiet. Just for 10 days delay, you want 1.5 years delay. You want 1.5 years time. Anyway, so there are 4 notifications. First 2 notifications, it went on extending. I have no problem, sir. The problem started when the other 2 notifications came, number 20 and number 38. Why? They extended the due date up to from 31st March. And that those 2 notifications, number 20 and 38, were dated 31st of March and 27th April. So they extended the due date up to 30th April and one more extended due date up to 30th June. In the intervening period, what happened, my dear friends? You went beyond 31st of March 21. Meanwhile, on 28th of March 21, Finance Act 21 is passed. Finance Act 21 is passed. But in April, you are telling, I will apply the old provisions of 147 in that board, in that those 2 notifications. They are telling in explanation, old provisions of 147 will apply. When? After Finance Act 21 is passed. First 2 notifications, no problem. They are within, before 31st March 21. Enjoy. After 31st March 21, other 2 notifications extended due date 30th April as well as 30th June 21. Notification 20 and number 38. So then they told, when Finance Act is passed as on March itself, you are bound to follow the dictum of 148 capital A, procedural law and substantive law. You are bound to follow the dictum of 148A before issuing notice under 148. But you have issued the 148 notice under the old law after passing of Finance Act in April 21. Therefore, rightly, all the 9 high courts in India quashed, including our Karnataka High Court, Mohammad Mustafa's case, Manmohan Kohli, Delhi High Court, etc. Allahabad, the Ashish Agarwal, etc. So now, ultimately, department filed an SLP against the Allahabad High Court only. This Union of India versus Ashish Agarwal is only against SLP filed by the department against Allahabad High Court only. And Justice M.R. Shah and Justice V.R. Nagaratna. So this entire order is around about 34 pages. There are around 12 paragraphs. Page number 1 to 3, details of civil appeal number, etc. is there. Then you come to page number 4, 34 pages, I told you 12 paragraphs. Now here they are telling, page number 4, para 1, aggrieved, dissatisfied with your common judgment order passed by High Court of Judicature, Allahabad. I told you it's only against the Allahabad. So now, High Court had allowed the writ petitions and quashed several reassessment notices issued by Revenue on the ground that same are bad in law in view of amendment by Finance Act 21. High Court has taken a lot of time, sir. 2 months, 3 months, hearing has taken place. After which only they have passed the orders, which has amended Income Tax Act by introducing new provisions. Revenue has preferred the present appeal. Para 2, they are giving all the judgments. Ashok Kumar Agarwal, Allahabad High Court, BPIP Infra, Rajasthan High Court, Manmohan Kohli, Delhi High Court, Bagaria Properties, Calcutta High Court, Manoj Jain, Calcutta High Court, single bench, Sudesh Taneja, Rajasthan High Court, Vellore Institute of Technology, Madras High Court, Tata Communication, Bombay High Court, etc. They are giving all those, all these are the judgments. Similar judgments are before. Now, para 2.1, page number 7, they say common judgment order passed by Allahabad High Court. Now, learned ASG, Additional Solicitor General Venkatraman Ji, is now telling Revenue is contemplating to file appeals against similar judgments and orders. As the issue is common, multiplicity of proceedings, lessen the burden of this court. He is telling, no, we propose to pass an order in exercise of powers under Article 142 of Constitution of India, unparalleled, my dear friends, unparalleled. And now the Supreme Court has invoked 142 to pass this order. Why? Because, they are telling 9,000 appeals. It will be huge burden. Issue is common, multiplicity of proceedings, huge burden on the court. 9,000 writ petitions, already 90,000 cases. These are the figures given by learned Additional Solicitor General in the order. It is coming out from the Supreme Court order itself. So earlier Article 142, it was invoked in Union Carbide's case for compensation to Bhopal gas victims. In allocation of coal block, 142(1) was invoked. For Ram Janambhoomi Trust, 2.17 acres of land was given to the temple. Round about 5 acres was given to for construction of mosque, etc. So these are the cases where 142(1) was invoked. So now for the income tax, now they have invoked this 142(1). They are telling for the cause of justice. Now, if you see here, next page number 13, then para 3.1, the Supreme Court is discussing about the Relaxation Act 2020, TOLA, these notifications. If you see this is what it is, main thing. 31st March 20, then 24th June 20, no problem. Come to 31st March 21, here it goes, extended limitation, very important. This 31st March 21 extended up to 30th April 21. This after Finance Act 21 is passed. Again 27th April extended to 30th June 21. So explanation to notification dated 31st March 21 and 27th April 21 issued under Section 3 of Relaxation Act stipulated that the provisions as they existed prior to amendment of Finance Act 21. Here only the revenue goofed up actually in the notification here. Shall apply to reassessment proceeding initiated thereunder. Then 14 to 19, they have given that substituted section 147 to 149, 151. I have not reproduced here. They have just reproduced. The Supreme Court in judgment has reproduced the new provisions as per Finance Act 21. 14 to page 19. Then page number 19, they are talking about this 140, 151, etc. Page number 19, para 4, they are telling, despite the substituted sections 147 to 151 coming into force, revenue issued approximately 90,000 reassessment notices under erstwhile section 148 to 151. Thereof, by relying on explanation in notification dated 31st of March 21 and 27th April 21. Then respective High Court, that's why struck down all respective assessment notices are held that issued under erstwhile sections 148 to 151, bad in law as reassessment notices issued after 1st April 21 are governed by substituted section 147 to 151. Consequently, all the high courts have set aside the respective reassessment notice wherever assailed, 9,000 notices only. But Honorable Delhi High Court, in its common judgment dated 15th of December 21, it also observed while quashing the respective reassessment notice that if the law permits the revenue to take further steps in the matter, they shall be at liberty to do so. Then page number 21, Supreme Court is telling the radical reformative changes are made governing procedure for reassessment proceedings, etc. Then they are telling, the earlier provision, valid reason to believe, etc. No tangible, reliable information, material possession of AO. That old Supreme Court judgments, Lakmani, Neval Das, etc. No inquiry being conducted by assessing officer prior to issuance of notice, change of opinion, Kelvin interest case, etc. Then GK and drive shot, etc. They are discussing. Then para 6.1, page number 22, Pre-Finance Act, Supreme Court is discussing this up to maximum 6 years, some cases beyond 6 years. So there was leading to uncertainty. Parliament thought it fit to amend the act to simplify, ease compliances, reduce litigation. Then para 6.2, they are telling, then they are discussing this new provision. 148 cannot be issued without following the steps of 148 8A, B, C, D. Then 6.6 para, they are discussing the substituted 149 has reduced the permissible time limit for issuance of such a notice to 3 years, and only in exceptional cases it is 10 years. Also provides further additional safeguards which were absent under earlier regime pre-Finance Act 21. Para 7, they are telling the new provisions substituted by Finance Act 21 being remedial and benevolent in nature and substituted with a specific aim and object to protect the rights and interest of the assessee as well as the same being in public interest. Respective high courts have rightly held, Supreme Court is telling respective high courts rightly held that the benefit of new provisions shall be made available in respect of proceedings relating to past assessment years, provided Section 148 notice has been issued on or after 1st of April 21. We are in complete agreement with the view taken by various high courts in holding so. Now they are going to take a U-turn here. However, at the same time, judgments of several high courts would result in no reassessment proceedings at all, even if the same are permissible under Finance Act 21 and as per substituted section. Revenue cannot be made remedieless. Object and purpose of reassessment proceeding cannot be frustrated. Bona fide mistake. So 90,000 officers issued 90,000 notices and everything was bona fide mistake. 90,000 officers issued 90,000 reassessment notices between 1st of April 21 to 30th June 21, post implementation, post passing of Finance Act 21. Not a single officer, followed the dictum of 148A. So now the Supreme Court is saying this is a bona fide mistake in view of subsequent extension of time, wide various notifications. Revenue issued impugned notices under 148 after amendment was enforced with effect from 1st of April 21 under the unamended 148. Then they are telling, in our view, they are same ought not to have been issued under the Unamendment Act and ought to have been issued under substituted provisions. So now they are telling genuine non-application of amendments as the officers of the revenue may have been under bona fide belief that amendments may not yet have been enforced. So they are telling some leeway must be given to these officers. Therefore, instead of quashing and setting aside, high courts ought to have passed an order construing the notices issued under unamended act, unamended provision as those deemed to have been issued under 148A. Now they are telling, therefore we propose to modify the judgment and orders passed with respect to high courts as under. Now the Supreme Court is telling 148A, whatever you issued, that whatever 148A notices, what you issued, 148 notices shall be deemed to have been issued under 148A of IT Act and substituted Finance Act 21. And they are to be treated as show cause notice in 148AB. Stop here. As and when you receive the notice under this show cause notice 148AB, earlier you issued notice under 148. That was reason to believe under old act, old regime 147. Reason to believe nowadays 148AB, old 148 shall be deemed to be show cause notice issued under 148AB. So now it is information suggesting income has escaped assessment. Earlier 148 issued was reason to believe. Now it is information. So that same reason to believe, has it now become information? Again, who was the authority? Sanction you took while issuing 148 notice. That was in the erstwhile provision of 151. Now there is new provision of 151. Question that again. Object. Now I told you only two types of authority. So where is the authority? Where is the approval? And that reason to believe, has it become information now? Anyway, treated to be show cause notice in terms of 148AB. Now respective assessing officer shall within 30 days from today, 4th of May, 30 days from today, probably 2nd June or 3rd June, whatever, as Rajesh Bhai pointed out. 30 days from today, provide to the assessee information and material. Stop again, object, information is fine. You will give me that inside portal, etc. What about material relied upon by revenue? Object again, give me the material. Where is the material? You are giving me information. There are 4 types of information. Finance Act 22, you saw, sir. 4 types of deemed information and 5 types of information. Finance Act 22, only 2 types of information. The deemed information, anyway, there are 4 types. 2 types of information only. So, respective assessing officer shall within 30 days from today provide to the assessee information, material. Give me the material. Be careful. Finance Act 21, only 2 types of information. RMS strategy formulated by board or final objection by C and AG of India. So, information means only these 2 types. Give me RMS information. Give me that RMS strategy formulated by board. I want to object. See, the RMS strategy, see that in project inside portal, so many information department is getting. I would have deposited cash in bank account, SB account, cash in my current account, I would have withdrawn amount, I would have sold shares, mutual funds, etc. indulge in trading in bitcoins, etc., purchased property, sold property beyond certain threshold, PAN, Aadhaar, bank, everything is linked. So many information is there, so much information there, GST turnover, etc. Based on that, that RMS risk management strategy formulated by board, it may change daily, like your stock market, your share market, speculation business, etc. It may change daily, it may change weekly, it may change monthly, it may change, yearly, etc. We don't know. So you share that. Based on that only, it should information suggesting income and escaped assessment. You have just deposited 1 crore in bank account. You're telling me this information which has escaped assessment? 1 crore I deposited bank account, sir. How can it be income escaping assessment? Information suggesting income has escaped assessment. You ask for the source, I'll give you the source. It may be out of my sales, it may be out of my earlier withdrawal, it may be out of that earlier withdrawal which I'm depositing now, it may be out of loan, it may be out of gift, what not. And the two, you are telling first 148.8A, first conduct inquiry, then give show cause. No. First you have to give show cause. What are they doing? They do not want to conduct inquiry. They are telling it's not compulsory. They give show cause, they do roving and fishing inquiry. Now they are asking there, you do your inquiry, then you have to record that information. Without this is mechanical non-application of mind. So everywhere you have to object, be careful, ask for the material also. And assessees can reply to the notice within 2 weeks thereafter. So within 30 days from 4th of May, give all the material, give all the information to assessee. And you are giving me only 14 days time. 148A, B, C, D. The section itself says give minimum 7 days time. Maximum 30 days time. You are giving me only 14 days time. That too they are telling you in the section, if you read, on an application made by the assessee, time limit also can be extended subject to satisfaction of assessing officer. But you are giving me 14 days time. It is in direct contrast to violation with the section. Anyway, so these are all objections you have to take, sir. You have to plead before the court authorities. We have highest respect for the judgment delivered by the Supreme Court. We have to show highest respect. But we can file all the objections as and when the assessing officer now issues the notices. Get ready for your drafting now. Don't miss a single full stop, comma, exclamatory mark. Everywhere you have to learn to object, object, object. We don't know which will hit the bullseye there now. Again, एक नए सिरे से शुरू करें हम लोग. जो अभी हम लोग objection file करेंगे और नए सिरे से file करेंगे objection against the notices again now. We don't know that what will hit the bullseye, and we don't know what the courts will accept. Not necessarily court need to accept whatever Naveen Khariwal argues. The honorable courts will decide for themselves. But I will not miss any opportunity to object. Keep filing an objection. I don't know which is valid, which is invalid, sir. Anyway, so these are the how they propose to modify the object. First, they are telling all 148 shall be deemed to be issued under 148AB. So that 148AB is coming now. So that reason to believe, you remember, now it has become information, and authorities are changed. Now, requirement of conducting any inquiry as a one-time, dispense with as one-time measure. No problem. 148A dispense with one-time measure. Okay. Then, thereafter, assessing officer will pass an order in terms of section 148AD after following due procedure and 148AB. No problem. Then all defenses which will be available. This is the mantra now. I read once, I read twice, I read thrice, I read fourth time. Fifth time we understood that it's a very, very balanced order. In fact, I compliment the Supreme Court. My compliments to Justice M.R. Shah and Justice B.V. Nagaratna. They have passed, you have to satisfy, my dear friend, 9,000 writs and 90,000 reassessment notices. That is why they have passed a very simple, cryptic, plain order. See, they have to take care of the interest of revenue, interest of the assessee also. And 90,000 assessees are there. 90,000 notices are there. So then the Supreme Court, Honorable Supreme Court is saying all defenses which may be available to the assessee under 149. Now they are coming in favor of the assessee now, which may be available under Finance Act 21 and in law. Very, very important, my dear friends. What do you mean by the word and in law? Most of us, we have read the Supreme Court order 5 times, 10 times. Tola, nowhere it is mentioned. What do you mean by end in law? In my humble opinion, this end in law may be, giving a link to Tola. All defenses which may be available to the assessee under 149 and which may be available under Finance Act 21 and in law, and wherever rights are available to assessing officer, whatever rights on Finance Act 21 are kept open. It is open-ended. The Supreme Court is telling you file your objections. you file your defense. All defenses are available, sir. Continue shall be available and shall continue to be available under Finance Act 21 and in law. The present order shall substitute, modify respective judgments and orders passed by respective high courts, quashing similar notices issued, irrespective of whether they have been assailed before this court or not. All 92 notices gone. Again, reassessment notice, fresh. It will start afresh now. Then broad consensus on the aforesaid aspects among the learned ASC appearing on behalf of revenue and learned senior advocates, learned counsel appearing on behalf of respective associates. Again, I know, my dear chartered accountants, my dear advocates, you are going to take a again objection that how can the advocates appearing on behalf of revenue and the assessees, how can you come to a broad consensus? There are 90,000 assessees. I know you are going to raise that query. For 90,000 assessees, how can you arrive at broad consensus? Consensus depends from fact to fact case of the assessee. So the advocates of the other assessees may not accept this. So anyway, the chartered accountants may not accept, advocates may not accept, etc. They are going to again, file their objections. Anyway, come down. They are telling it will strike a balance between rights of revenue as well as respective assessees, as because of a bona fide belief of the officers of the revenue in issuing approximately 90,000 such cases. Here I would like to disagree with the Honorable Supreme Court. 90,000 officers issuing 90,000 notices, not one of them knew that these notices are issued post Finance Act 21. None of them knew. You are the lawmaker, you are the law framer, you are the law creator. And you yourself are telling, I don't know the law. And genuine bona fide mistake on behalf of 90,000 officers in issuing 90,000 notices. So that is why the Honorable Supreme Court goes on to say that revenue may not suffer, as ultimately it is the public exchequer which would suffer. Anyway, therefore, we propose to pass the present order with a view to avoiding filing of further appeals before this court and burden this court with approximately 9,000 appeals against similar judgments and orders passed by various high courts. We have also proposed to pass the aforesaid order in excess of our powers and Article 142 of Constitution of India. Clearly, Supreme Court is telling the present order shall govern not only impugned judgments and orders passed by High Court of Allahabad, etc., shall be made applicable in respect of similar judgments and orders passed by various high courts across the country, and therefore present order shall be applicable to pan India. So here, this is the modified, substituted as under para 10. So all these are the the directions and observations of learned Supreme Court, Honorable Supreme Court. Present order shall be applicable pan India, all judgments and orders passed, etc., under which similar notice issued under 148 set aside and shall be governed by present order shall stand modified to the aforesaid extent. Supreme Court is telling this, sir. I am not telling. Present order is passed in excess of powers and Article 142 so as to avoid any further appeals by revenue on the very issue by challenging similar judgments and orders. Now, move forward, sir. So we discussed that background for Supreme Court judgment. These are all binding observations by Supreme Court, which we discussed. Anyway, so now this Bombay High Court, immediately they on the very next day itself, they disposed of all the petitions challenging 148 based on Supreme Court ruling. Now, in fact, my office has also received 2 notices already based on the Supreme Court judgment already. Now they come to the instruction, sir, 11th May 2022. Sir, I can't fathom, I can't understand, I can't believe. By issuing this instruction again, the revenue has shot itself in the foot again. How beautifully, to capture their case, to make out their case, how they have extended the time limits. But in all my humility, in my opinion, the instruction will not, stand the test based on the Supreme Court judgment at in any court of law. So that is my opinion. Anyway, we will discuss further. What is the honorable, the instruction dated 11th May discussing? Come to straight away. Para 6.2. See, they understood that revenue is discussing 149.1 as amended by Finance Act 21 before its amendment by Finance Act 22 reads as under, etc. So 3 years, more than 3 years, but less than 10 years, etc. They are telling. Now, what are they telling? See the instruction. Honorable Supreme Court has upheld the views of High Courts that the benefit of new law shall be made available even in respect of proceedings relating to past years. Yes, sir, we agree in tandem with the Supreme Court judgment. Decision of Supreme Court read with time extension provided by TOLA will allow extended reassessment notices to travel back in time to their original date. Back in time in their original date. When such notices were to be issued and then that 149 of that is to be applied at that point, TOLA is only for old 147 regime, sir. TOLA can never be attached with the new 147 provisions. TOLA is only for the old 147 regime. Now, based on the above, the extended reassessment notices are to be dealt with as under this, the board circular. Now, 13, 14, 14, 15, 15, 16. Fresh notice under section 148 of the Act can be issued in these cases with the approval of specified authority only if the case falls under B. That is, beyond 3 years and up to 10 years, as amended by Finance Act 21. Okay, earlier it was up to 4 years and beyond 4 years up to 6 years. So 13, 14, March 20, 14, 15, March 21. But these two, were alive because of TOLA, because all the notices issued between 1st of April 21 to 30th June 21. So now, thankfully, at least the instruction says what notice could be issued only beyond 3 years up to 10 years only. That too, if it is beyond 3 years up to 10 years, it is what? Should be the asset, represented by asset, and should be more than 50 lakhs. So thankfully, at least 50% of the cases will go. Most of the cases were for 13, 14, 14, 15. All less than asset, etc. Income scheme less than 50 lakhs cannot be reopened. That much, at least the assessees, the board, the Supreme Court, as well as this instruction, everybody agrees. So to that extent, litigation has died down now. So out of 90,000 cases, say around about 50%, maybe less than 50 lakhs for 13, 14, 14, 15, it has gone. So he is telling fresh notice under 148 can be issued only with approval, okay, if the case falls under B, that is beyond 3 years up to 10 years, as amended by Finance Act 21 and reproduced in paragraph 6.1 above, etc. 16, 17, 17, 18, very smart. Fresh notice under 148 can be issued in these cases with prior approval of specified authority under clause A, 3 years from the end of assessment year, 16, 17, 3 years from the end of assessment year, March 20, 17, 18, 3 years from the end of assessment year, March 21. But you put TOLA. If you put TOLA, get it stretched up to 30th June 21, then it will go up to March 22. So they are telling, since they are within the period of 3 years from the end of assessment year, they are not actually within 3 years here. 17 means March 20, 18 is March 21. But because of TOLA, they are telling, in this case, I can issue notice because it is 3 years from the end of assessment year. Because if you add TOLA, time limit gets extended up to 30th June 21 in both these cases. Now, cases where assessing officer required to provide the information material relied upon within 30 days. Board circular, your board instruction is telling, sir, provide information and material. I am not telling. The Supreme Court also gave a direction. Board circular is also telling this information, material. So within 30 days, you have to give me material, you have to give me information. Honorable Supreme Court para 7.1 of this board circular clearly says Supreme Court has directed information and material required to provide in all cases within 30 days. However, it has also been noticed that the notices cannot be issued in a case for 13, 14, 14, 15, 15, 16 if the income escaping assessment in that case for that year amounts to or likely to amount to less than 50 lakhs. So they agreed themselves. So for 13, 14, 14, 15, 15, 16, why? For 13, 14 it is March 20. For 14, 15 it is March 21. 15, 16 it is March 22. So because of TOLA, the 13, 14, 14, 15 went to 30th of June 21. So it's telling more than 50 lakhs, in less than 50 lakhs, you cannot issue now. Because it is beyond 3 years from the end of assessment year and up to 3 years from the end of assessment year, you cannot issue. Beyond 3 years, up to 10 years, they are telling very well. If more than 50 lakhs, issue. Less than 50 lakhs, keep quiet. Up to 3 years, I'm telling you, no question of less than 50 lakhs, more than 50 lakhs. It is my personal opinion. No limit, sir. Up to 3 years from the end of assessment year, it may be 1 rupee, it may be 51 lakh rupees. No question of less than 50 lakhs or more than 50 lakhs. Beyond 3 years, up to 10 years only, it should be more than 50 lakhs. Hence, in order to reduce the compliance burden, it is clarified information and material may not be provided in a case for 13, 14, 15. If the income escaping assessment in that case for that year amounts to likely amount less than 50 lakhs. Simple, they are telling. Less than 50 lakh, we need not give any information material. Separate instructions shall be issued regarding procedure for disposing of these cases. in order to reduce compliance burden, clarified that information and material may not be provided in a case for assessment year 13-14, 14-15, 15-16. Clearly, they say if the income escaping assessment in that case for that year amounts to or likely to amount to less than 50 lakh rupees. Now, clearly say case falls under B. That means what, sir? Beyond 3 years up to 10 years. So up to 3 years and less than 50 lakhs, no problem. Beyond 3 years, more than 50 lakhs, instruction is telling. My opinion, I'll give you later. Instruction is telling more than 50 lakhs, please issue. Now, procedure required to be followed by assessing officers to comply with Supreme Court judgment. That, as the courts have decided, they are going to follow 148 AB. Now, first of all these cases, they all went to NFAC, National Faceless Assessment Center. From NFAC, they have to be pushed back to all the JAO, jurisdictional assessing officers. Functionality is to be enabled in the portal for 13, 14, 14, 15, 15, 16, etc. Whatever you want. It has to come back. It has to come back in their system. And functionality also, you open it, sir. So that within 30 days, you can give me all the material, you can give me all the information. Thereafter, 148 AB, I will file my objection. Thereafter, you will issue 148 AD. Along with 148, thereafter, I will file my return in response to 148. Thereafter, you will issue notice under 143 too. Thereafter, it will be taken up for assessment and thereafter, order will be passed. Anyway, so this clearly para 8.1 is telling within 30 days, that is by 2nd June 2022. I am not telling, sir, the board circular is telling. Clearly, they are telling, the board is telling by 2nd June 22, hey, assessing officer, you should provide to the assessee in all cases information and material relied upon for issuance of extended reassessment notices. They themselves are telling by 2nd June 22. Assessee has 2 weeks to reply as to why notice under section 148 should not be issued. On the basis of information, he suggests that income chargeable tax escaped assessment. Time period of 2 weeks shall be counted from the last date communication of information material by assessing officer to the assessee. He can also drop, no problem, sir. If you explain nothing escaped assessment, there is no information escaped assessment, etc., he will drop. Order will be passed stating that it's not a fit case for reassessment, etc. If it is not a fit case to issue a notice, order passed on D to that effect shall be served on the assessee. Absolutely no problem. Now the analysis of your CBDT instruction. Now in this instruction, CBDT has stated that reopening for 16, 17, 17, 18 can be done under the new section 149(1)(a). That is 3 years from the end of assessment year because of the TOLA, yeah. But I don't agree with that. And same can be done for 13, 14, 14, 15, 15, 16 under 149(1)(b). That is beyond 3 years up to 10 years. I told you, while interpreting so, CBDT has considered decision of Supreme Court read with time extension provided by Taxation Other Laws 20 TOLA, and as instructed, such combined reading will allow extended reassessment notices to travel back in time to their original date when such notices were to be issued, and then new section 149 of the Act is to apply at that point of time. So, Supreme Court has already held that action of revenue in issuing notices under unamended section 148, applying the TOLA was a mistake. Then now CBDT is again taking shelter of TOLA even for application of substituted provision of 147 to 151. I told you TOLA is only for old provisions, sir. TOLA cannot be substituted for the new provisions, for the substituted provisions of 147 as per the Finance Act 21. TOLA notifications were issued only for unamended provisions. Same cannot be automatically applied by CBDT to the substituted provisions of 147 to 151. Particularly when at first also the application of TOLA and consequent action has been termed as bona fide mistake of the revenue by the Honorable Supreme Court. Therefore, coverage of 149(1)(a), no notice under 148 shall be issued for relevant assessment year if 3 years have elapsed from the end of relevant assessment year. So anyway, 13, 14, 14, 15, it is time barred. 13, 14 up to March 20, 14, 15 up to March 21, and then Finance Act 21 came into being. So today you cannot issue for 13, 14, 14, 15. All right, you know that 148 AB, if you have issued up to 31st March 21, I have no problem, sir. But if the notice was issued, that 90,000 notices between 1st of April to 30th June 21, it is void of initio, invalid. 13, 14, 14, 15, both. 2018, 19 onwards will be covered under this clause. This is the position as on from 1st April 21. Even your board agreed now when they came out with that circular 10 December 21. They told 18, 19, 3 years from the end of assessment year. 15, 16, they told 6 years from the end of assessment year. No notice for 17, 18 early years could be issued under this clause. Why? Because 6 years, they are simple telling now. How you have to go through now? We'll see now. Now coverage of 149 1B again, no notice and 148 shall be issued for relevant assessment year if 3 years but more than 10 years have elapsed, unless the assessing officer has in his possession books, documents or evidence. So beyond 3 years up to 10 years, if the assessing officer wants to reopen, he should have in his possession books, documents, evidence. Rule 6F sub rule 5 says maintain books of account need not be maintained for more than 6 assessment years. You want to reopen for 10 years and you want to give books of accounts. So 6F, rule 6F sub rule 5 itself says maintain books of account not beyond 6 assessment years. Now you are telling me possession, suppose it is there in possession, then assessing officer, rightly pointed out by Rajesh by, survey, etc. So books should be there in the possession of the assessing officer. Books of account, documents, evidence. That too should reveal income chargeable tax is escaped assessment. That should be in the form of an asset only, asset. That too exceeding 50 lakhs per annum. This for Finance Act 21 only. But again, see the first proviso. Provided no notice 148 shall be issued at any time in case beginning on or before 1st day of April 21, if such notice could not have been issued at that time. So 13, 14 finish, sir, Mark 20, I can't. 14, 15, Mark 21, I can't. No. As per the law prevailing before commencement of Finance Act 21, maximum reopening can be done up to 6 years from the end of assessment year. That is, reopening can be done from 15, 16 onwards if you see the position as on from 1st April 21. Therefore, reading the provisions of 149, its first proviso and decision of Supreme Court, it can be concluded that revenue can reopen assessment years from 14, 15, 16, 16, 17, 17, 18 only under substituted provision of 149 of the Act as per Finance Act 21. So what are they telling? Reopening can be survived for 15, 16 onwards as all prior assessment years will be beyond limitation of 6 years as per first proviso to 149. Reopening proceedings for 15, 16 and 17, it can be only under 149 1B. Up to 3 years is gone. Only it should go beyond 3 years up to 10 years. Can be continued only if quantum of escapement exceeds 50 lakhs and same is represented in form of any asset. And for all such reopening, there should be income which has escaped assessment, which has income information suggesting that there is an escapement of income. Yes, sir. Moving forward. Yeah. So coverage of 13, 14, 14, 15, though the same appears to be time barred as on 1421, that is the date from which amended provisions of 147 to 151 are applicable in view of the first proviso to 149. Then coverage of 16, 17, 17, 18 within 3 years category, though the same appears to go beyond 3 years as on 1421, that is the date from which amended provisions of 147 to 151 are applicable in view of first proviso to 149. Now see, this is one view. Now understand carefully. So 13, 14, 14, 15 are time barred based on that board instruction. Then based on the board instruction, they are telling for 15, 16, 16, 17, 17, 18, etc. You go under 149 1B, that is beyond 3 years up to 10 years. You can please go. That means income should be more than 50 lakhs, asset, etc. That is why 18, 19 in March 22, department they wanted to reopen. Why? Because up to 3 years from the end of assessment year, that limit is not there, 50 lakhs. Now I am giving you my view, my dear friends. It has to be tested before the courts. Let me warn you. It has to be tested before the court of law. This is my view. And I am going as per limitation, as per amended section 149 first proviso. What could not be done then also cannot be done now. Very simple. Start with assessment year 13, 14. 6 years from the end of assessment year. 147 old regime. March 20. Very good. And limitation applying TOLA was 30th June 21. So where is the question of 3 years regime now? There is no question of 3 years or 10 years. So the High Courts also struck down that 30th 13, 14, March 20, finished, 6 years finished. Then this March 15, assessment year 14, 15, up to March 21, finished. 6 years from the end of assessment year over. Why? That is the cut-off date because Finance Act 21 is passed then. So limitation applying to law, what department is told now, 13, 14, 14, 15. only they are telling what? Up to 3 years. We are anyway with you only. We don't want to issue notice. But department is telling beyond 3 years up to 10 years. Why? Because of this limitation date TOLA 30th June 21, they have extended up to March 22, which I am telling you may be incorrect. The courts will hold it as incorrect because TOLA applied only to the earlier old regime and not to the new regime. So 13, 14, 14, 15 will not be possible. In my opinion, even 15, 16 will not be possible. Why? 15, 16, what is the limitation, sir? Again, 6 years from the end of assessment year, March 22. So therefore, no question of applying TOLA here. 3 years regime, 3 years is done with now, and 10 years is also done with. You cannot come here. Why? I will tell you now. Today, if there is a search, take for example, today there is a search. Today is 18th May 22. So we are in assessment year 22-23. Assessment year 22-23 means 21-22, 20-21, 19-20, 18-19, 17-18, 16-17, 15-16, 14-15, 13-14, 12. So as it looks, my dear friend, is purely my personal view. Now I am telling you, today if there is a search, department can go up to 3 years, beyond 3 years, up to 10 years. There is no 153 ABC in the Act today. They will all follow this reassessment procedures, this substituted reassessment procedures. So they can go up to 22-23. We discussed that because today I am now in assessment year 22-23. Sorry, you can go up to 12-13. But you cannot go up to 12-13. Why? Because grandfathering provisions are there. Because whatever was not surviving as on 1st April 21, first proviso 149(1, as on 31st of March 21, whatever has expired, see the notice as on 1st April 21, what could not have been done then cannot be done now. Even though today there is a search, you go 10 years backwards. Now we are in assessment year 22, 23, 21, 22, 20, 21, 19, 20, 18, 19, 17, 18, 16, 17, 15, 16, 14, 15, 13, 14, 12, 13. Department will not be able to reopen up to 12, 13, even though there is an income escaping assessment beyond 50 lakhs. Why? Because the first proviso will come in between the department and associate. It will come to the rescue of the associate. Will come against the department. What could not have been done then? For example, take this 16, 17, March 23. Everywhere you take 6 years from the end of assessment year first. Because they are telling as on 1st of April 21, this, please see the 6 years, 31st March 23, 31st March 24, 31st March 25, 26, 27, no problem. So yes, notice after 2nd June 22, beyond 10 years, I can definitely reopen, but only up to 23, only up to 24, only up to 25, only up to 26, only up to 27. For example, this 18, 19, I can suppose there is a search, limitation applicable is March 29. Why? 10 years. When you put 10 years, my dear friends, 18, 19, limitation as per amended section 149, first proviso is 6 years from the end of assessment year, March 25. Limitation of 3 years from the end of assessment year is March 22, no problem. 10-year regime is March 29. It looks to you now, 10 years, yes, March 29. But the problem is this first proviso will come and limit it. Instead of March 29, I can go only up to March 25. I am not telling this is the final view. In all humility, this is my personal view. So the courts may take a different call. Courts will take a different call. May take a different call. I am not the judge. So this is what I have analyzed because I am applying first proviso now 149. Clearly they are telling up to 31st March 21, any notice issued on or after 1st of April 21. So this proviso acts will restrict this 10 years. So they are telling go up to now. Time limit is very clear, sir. 3 years from the end of assessment year, because as of today, substituted provision of 149 will apply. That is subject to first proviso. Be up to 3 years, beyond 3 years, up to 10 years, which is subject to first proviso. This is one of the views, and this is my view in all humility. It has to be tested before the court of law. So all this, various, your lots of issues and controversies will be there. And as I told you, you have to object at every level, my dear friends. See, this may look benefit to the assessee now because you are not able to reopen here on this stand. But I am telling you again and again, it has to be tested before the court of law. Now, issues and controversies. Now, as I told you, this 148 AD, if they pass, again, it will be a matter of writ. Why? Because suppose you don't give the information, you don't give the material, you don't follow the principles of natural justice, you don't consider reply of the assessee, etc. it's a non-speaking order basically, then challenge of the same shall be available in writ jurisdiction and there is no appeal remedy. Let me tell you again, 148 AD, there is no appeal remedy. So therefore, you can only file a writ. Then again, Supreme Court has clearly observed what defenses as per 149, as per Finance Act and under law. So therefore, as regard assessee is concerned, this shall mean if the case which could have been opened up to 31st March 21 cannot be opened after 1st April 21. See first proviso to 149 of that as applicable in effect from 1st April 21. The cases for 13-14 due to extended period, there is 6 years plus 1 year, and for 14-15, 6 years could not have been opened after 31st March 21. And hence the same cannot be opened with effect from 1st April 21 as the first proviso to section 149 as applicable with effect from 1st April 21. However, for other assessment years, etc., different views. Now, reason to believe versus information possession, etc. Still, you take all those case laws. They are all, old wine in new bottle. Take all the reason to believe case laws. You analyze, break them up. Take all the reason to believe case laws. Analyze, break them up in 148A, B, C, D. Dump it there. A, B, C, D. You put that, and then you file your objections. Moving forward. Now, one beautiful letter was raised. Actually, I don't know whether it's there in WhatsApp. The gazetted info, the information, the income tax officers gazetted association. They have issued very pertinent questions. Should be circulating in WhatsApp. Very beautiful questions they have asked. That only that has been incorporated in your circular actually, but not fully. So here one of the questions what they are asking in that letter, during the period from 1st April 21 to 30th June 21, notices were issued based on information from 4 sources, which from AOs, from other agencies, and from investigation mean inside portal. Other than information received from inside portal, no other source qualify for criterion of flagged in accordance with risk management strategy. Will the AO proceed in these cases where information is not flagged in accordance with risk management strategy? So there are only 4 sources of getting information where AO can proceed in 148. Issue that is debatable is that what are the risk management strategy, how information is flagged, and whether these information are in public domain. Issue further arises that whether the assessee can raise any objection that if information is flowing to the AO from a source which are not mentioned above, then there are generally 5 types of cases which are pending for 148. These are as under assessee who have filed writ petition or who did not file writ petition before any high court, but they challenge the validity of notice before the JAO without relying on any of the decisions from high court. Assessee who did not file any petition themselves, but after the verdicts of different high courts, challenge the validity of notice before the JAO, relying on such decision, who has not challenged the issue of notice at all, who has not challenged the issue of notice and filed idea in response to the notice. So whether the AO is required to send information, consequently pass order 148 AD, followed by issue of notice 148 in fit cases to all assessees as above or only to certain segment. All the cases need to be separately analyzed by AO in terms of amended provisions, limitation applicable, then only proceed with 148 AD. They went to meet the officers in the department. Practical problem they are telling, sir, the information is coming only to us before a few days. What to do they are telling? We are all ground level officers. Information is not coming to us. It is coming only in the fag end. When it comes in the fag end, where is the question of application of mind? Where is the question of mechanical application of mind, or it has to be mechanical only then, because they are in a hurry. Suppose the notice is not issued, so they are afraid of that. It comes at the fag end. The officers they are burdened practical problems they are facing. So immediately they have to issue the notice. Now please imagine, for more than 3 years and up to 10 years and more than 50 lakhs, etc., everything has to be signed by Principal Chief Commissioner of Income Tax. So he will be still burdened, 7,000, 8,000, 20,000, 40,000 notices, example. Where the question for him for mechanical, sir, where the question of application of mind, it will be mechanical only. Immediately he has to give approval, keep on giving approval, again it has to be issued then. Anyway, these are all practical problems. ITBA portal, etc. And then modification also will be required on the ITBA portal to overcome that technical glitch. Now, something again struck me. Finance Act now, when they are issuing notice under 148 AB, it's going to come, as you told, now up to 2nd June. Assessing officer has told. We are in which Finance Act, sir? Finance Act 22 is there. Officer issuing 148 AB. What happens if they take shelter of Finance Act 22? Supreme Court is telling Finance Act 21. No, officer is saying I am in the assessment year where I have to follow Finance Act 22. Example. He will tell, I will go because the scope of information is enhanced by Finance Act 22 vis-a-vis Finance Act 21. 2 types of information or 5 types of information. Therefore, and also Finance Act 22 further widened the time limit for issue of notice, provided that the notice under 148 can be issued after 3 years and up to 10 years, where assessing officers and is in possession books of account, document, evidence which reveal the income chargeable tax represented in form of asset, expenditure, entry or entries in books of account. So the assessing officer may tell, I will take Finance Act 22. As per Supreme Court judgment, all such impugned notices issued on or after 1st of April 21 and up to 30th June 21 under old section 148 shall now be deemed to be issued under 148A as per Finance Act 21, and the assessing authority is supposed to issue consequential notice on 148 after complying with the requirements of 148A and other amended provisions of 147 to 151. Therefore, all such consequential notices on 148 are now issued at present, that on or after 1st April 22. When the amended provisions of 148 are in place by virtue of Finance Act 22. So some adventurous assessing officer may adopt the extended definition of the meaning of the term information as per amended explanation 1 to 148 as per Finance Act 22 to include any information in any audit objection, including that of the internal audit department, not just the final objection of C&AG, for reopening the cases for 3 years for the impugned deemed notices 148 of the Act, etc. However, if the revenue authorities attempt to adopt and make applicable extended scope of term information, then and liberal criteria of spreading up of escaped income to all 10 years, simultaneously, assessees will also get equivalent right to argue that such an interpretation will simultaneously reduce the validity of issuance of notices issued on or 1st of April 22 for one more assessment year. That is in case of alleged escape of income up to 50 lakhs to assessment year 1920. And in case of alleged escape income exceeding 50 lakhs to 1213, subject to my other view. Now, some time for complete justice, we will just see and then try to take up questions. That Article 142 of Constitution of India. Now, basically, this article, I told you, the court, Honorable Supreme Court has invoked the Article 142 for doing complete justice in a given case. Article 142 we produced as under, we discussed that also. Just for 2 purposes. Why they invoked? To grant relief to do complete justice in a given case. Rehorse the applicable statutory provisions. People are going to raise the objections. Nothing stops them. They are going to tell when the statutory provisions were very well there in the enactment. Article 142 you have to invoke if there were no statutory provision, but statutory provisions of the newly amended provision was there. Then to issue directions to fill what the court perceives as legislative gaps, which directions operate as the law of the land until such time that the legislature or executive steps in. So up till now, power granted under Article 142 of the Constitution of India has been exercised by Honorable Supreme Court majorly in case of public interest and social justice and unrelated to tax laws. Now, in the landmark judgment of A.R. Antule versus V.R. Naik Supreme Court, it was stated that Supreme Court can grant appropriate relief where there is some manifest illegality, where there is manifest want of jurisdiction, where some palpable injustice is shown to have been resulted. Such a power can be traced to either Article 142 or power inherent to the court as a guardian of Constitution. So various judgments, various case laws we have discussed. When we discussed that earlier also 142. Now, moving further, there is this landmark judgment of Honorable Supreme Court on limiting factor. What is the limiting factor on invocation of 142? Again, Supreme Court only. How 142 limitation is put. Very beautifully analyzed in ESP Rajaram versus Union of India. Very beautifully analyzed the direct discretion and limitations of invocation of power granted under Article 142 and as held as under. Said provision vests power in Supreme Court to pass such decree or make such order as is necessary for doing complete justice in any case or matter pending before it. The provision contains no limitation regarding the causes or the circumstances in which the power can be exercised, nor does it lays down any condition to be satisfied before such power is exercised. The exercise of the power is left completely to the discretion of highest court of the country, and its order or decree is made binding on all courts or tribunals throughout the territory of India. However, the Supreme Court goes on to further say this power is not to be exercised to override any express provision. It is not to be exercised in a case where there is no basis in law which can form an edifice for building up a superstructure. This court has not hesitated to exercise the power in Article 142 of Constitution whenever it was felt necessary in the interest of justice. In fact, the Supreme Court judgment is also referring to one more Supreme Court judgment, 3-bench judgment MS Alawat versus State of Haryana. Supreme Court under Article 142 of the Constitution, Supreme Court cannot altogether ignore the substantive provisions of a statute and pass orders concerning an issue which can be settled only through mechanism prescribed in another statute. Anyway. So these are all, host of various other Supreme Court judgments. No, it may be referred to a larger issue. It may go for review because they are selling based on consensus. Your opinion as good as mine. So we can only wait for the future. It may need to be reviewed or referred to a larger bench for the following reasons. We are discussing several other Supreme Court judgments. However wide and plenary the language of the article, the directions given by court should not be inconsistent with, repugnant to, or in violation of specific provisions of the statute. Power under Article 142 must not only be consistent with the fundamental rights guaranteed by Constitution, it cannot even be inconsistent with substantive provisions of the relevant statutory laws. It, however, needs to be remembered that powers conferred on the court by Article 142 being curative in nature cannot be construed as powers which authorize the court to ignore the substantive rights of a litigant while dealing with the cause pending before it. This power cannot be used to supplant substantive law applicable to the case or cause under consideration of the court. Article 142, even with the width of its amplitude, cannot be used to build a new edifice where none existed earlier, by ignoring express statutory provisions dealing with the subject and thereby to achieve something indirectly which cannot be achieved directly. So these are all, Supreme Court judgment after all. Parshuram Pottery's case, the famous Supreme Court judgment. Policy of law is that there must be a point of finality in all legal proceedings, that stale issues should not be reactivated beyond a particular stage, and that lapse of time must induce repose in and set a trust judicial and quasi-judicial controversies as it must in other spheres of human activity. So one must not forget that notification number 20, I told you, 20/21 dated 31st March 21 and 38/21 dated 27th April 21 were issued against the latest will of legislature by Finance Act 21. Hence, the question of bona fide does not arise at all. Pertinent to note that Honorable Supreme Court has only held that issuance of notice under erstwhile 148 deemed to be notice issued under 148A and provision of 148B is complied with. AO has to necessarily pass an order in terms of 148AD. Thereafter, and all subsequent proceedings have to be complied with in accordance with law. Therefore, court has also ordered that all defences which may be available to the associate under 149 or which may be available in Finance Act 21 and in law, and whatever rights are available to AO under Finance Act 20 are kept open, continue to be available. Consequently, impugned notice, if any issued under 148, would not survive considering the time limit under amended provisions of 149. As per substituted provision of 149 1A, no notice under 148 shall be issued for relevant assessment year if 3 years have elapsed from the end of assessment year. Hence, the department can now issue notice under 148 only with respect to 1920 and thereafter. One may refer to para 4 of decision of Ashok Kumar Agarwal, your Supreme Court judgment. Honorable Allahabad High Court has listed the risk petitions filed by SSC, which went on to Supreme Court now. Ashish Agarwal. That is different. This is, one may observe that assessment years involved in the petitions were assessment year 13, 14, 14, 15, 15, 16, 16, 17, and 17, 18. Hence, the department cannot issue notice under 148 for the impugned assessment years, which were the subject matter of dispute before the Honorable Supreme Court. Without prejudice, notice under erstwhile provisions were issued on the basis of alleged reason to believe, etc. Raymond Ullen Mills. It was held that sufficiency or correctness of the material was not a thing to be considered at this stage. Section 148A now provides what? Prior opportunity to file objections. Correctness and sufficiency come with the word has escaped assessment. Hence, the notices under erstwhile 148 issued on different edifices cannot survive under substituted provisions of reassessment, which require concrete material to establish that income has escaped assessment. So recently also writs have been filed against 148 AD, so I have given those details. Taxpayers Charter. So at the end, the 119A, Income Tax Department committed to provide a fair, courteous, reasonable treatment, provide fair and just system, reduce cost of compliance, etc. Provide complete and accurate information. Expect taxpayers to be honest, compliant, be informed, keep accurate records, respond in time, pay in time. Know what the representative does on this behalf. Thank you very much, sir, for a very patient hearing. Ashish bhai? Yes, sir.
Yes, sir. Thank you so much, sir, for the wonderful session, sir. Sir, we have a question from the participants.
Yeah.
First question from CA Khariwal, sir, who is a past chairman of Ahmedabad branch as well. Sir,
best branch all over India.
Yes, sir. Sir,
Pardon, sir. Yes, sir.
Case is reopened due to client code modification by broker on NSDL commodity platform. It was considered escape income of rupees 1.48 crores for assessment year 14-15.
Okay.
Whether it can be reopened in view of Supreme Court judgment, or can the amount involved due to client code modification is considered to be represented by asset as per section 149(1)(b).
Okay, so what is the question? Very genuine, pertinent question. It's for assessment year 14-15. So therefore, this will come, Supreme Court judgment will come into play only if it is issued between 1st of April to 30th of June. Secondly, now 148 AB is going to come, and then you file your objections saying that because it is more beyond 3 years and up to 10 years from the end of assessment year. In my case, in my opinion, first of all, the TOLA, so 13, 14, 14, 15, you cannot reopen. But anyway, based on the board instruction, what are they telling is, in case it's beyond 3 years up to 10 years, if there is an asset and that asset is more than 50 lakhs, reveals that income escaping asset more than 50 lakhs, then I can very well reopen. So you have to file your objections basically. When you receive 148 AB, please file the objections to this effect. And also, whatever these penny stock cases are there, this asset, how do you prove what is in form of an asset? This entry is this. Now, what are they telling? There are only 4 types of assets. Whether that asset is in form of land and building, whether it is in form of loans and advances, or whether it is form of your shares and securities. It is in form of shares and securities, or it is in form of your deposits in bank account, etc. So you file your objections.
Right, sir. Sir, one question from Nitin ji. Do the AO have to record that no inquiry is needed as specified under section 148A?
Okay. Yeah, I told you, sir, in my opinion, actually there is a need to do the inquiry in all non-search, non-survey cases. Other than I told you those cases where it's deemed information, AO is not going to give you opportunity, sir, of 148 ABCD, etc. He's not going to take you through that steps. Those steps will not come. No question of doing any inquiry if required. So where is it required then? It is required in other than survey, other than search, etc. And even for survey, let me tell you, if today there is a survey 3 years from the end of assessment year, 3 years cases will be reopened, sir. So be careful now.
Right, sir. Chetanji is asking, AY 1617 can be reopened considering Supreme Court judgment.
Sir, the board circulation, it appears from the board circular. That's what they are telling. 16, 17, 17, 18. They are telling 3 years from the end of assessment year. They are applying TOLA. 16, 17, 17, 18. Board circular says they will apply TOLA. And they are telling it extended by 1 year. Applying TOLA 30th June 21, 16, 17, 17, 18. So what was up to March 18, March 20th and March 19? They could not have reopened actually up to 3 years. But now because of that board instruction, and they are reading that Supreme Court judgment along with TOLA, naturally the department wants to reopen. You file your objections. You have to file your objections. Right. But they are going to reopen, sir. As of now, everything will become alive. This is a far-fetched stand by the department, which I don't agree. Anyway, but it will give rise to litigation. Orders which we passed. And 148(8)D itself, you can file a writ petition.
So Chetanji is again asking, is information gathered during survey or search of a third party could be information for reopening of case in our assess's case?
Correct. It is already there, sir. In deemed explanation 2, 1, 2, 3, 4. The next 2 points, 153C type cases, it has come. It has come there.
Right.
100% it can be, sir. No doubt about it. Deemed information, explanation 2. There are 4 types. First is your search, survey, etc. And then first is the search 132 or requisition 132A. Then you come to survey. Then next 2 points, jewelry, bullion, etc. seized. And then next one says books of accounts or documents. Pertaining to. So those 2 definitely it will come. 153C type cases.
Sir, Anilji is asking, respected sir, in case of AY 1617, AO is trying to reopen the case on the basis of search conducted on someone else before 1st April 2021. So is it valid in terms of time of 3 years? And if yes, it's still valid as the search is before 1st April 2021 and not after?
I got it, sir. Very, very good question. My dear friend Anilji, you are forgetting erstwhile 153C, 153A, which you assess. Forget this Finance Act 21 amendment. Earlier, people are forgetting there was 153C, 153A. Beyond 6 years, I could go beyond 6 years up to 10 years. When income has escaped assessment by 50 lakhs. That mistake department forgot and they inserted in Finance Act 22 now. That has come 153A and C. You have forgotten not only now 10 years. Earlier also I could open now 153A and C. Remember, beyond 6 years up to 10 years, where income escaping assessment is more than 50 lakhs.
Right, sir. Sir, Priyasji Ruparel is asking, sir, how do we come to know that inquiry has been conducted under section 148AA before issuing order under section 140 or AD? It is seen that there have been cases of mechanical approval. Is there any method to identify that inquiry under clause A has been conducted?
Very good question, sir. So now I am telling you, everywhere you have to ask for the approval. There are 4 or 5 types of approval. You ask for the approval. Please give me the approval and also share me the details of the inquiry. You ask them, please give me that whatever inquiry conduct, give me the details. You have to ask them.
Okay. Bhavilji is asking, sir, notice under section 148 dated 12th April 2021 for assessment year 1516 is received. Return of income is filed in response to this notice on 10th May 2021. Now order under section 148 AD is passed, determining that it is a fit case for issuance of notice under section 148. Notice under section 148 is received. Is it now necessary to file ITR again in response to new notice under section 148?
Sir, again, please understand very, very pertinent practical questions. Now, what are they telling? In so many cases, 148 would have issued, you would have filed written, and you would have kept quiet. Now they are telling that 148 what was issued, will become 148AB. That means 148AB will precede 148. 148AB will go on to become 148AD. Then again 148 will be issued. But in this case already 148 is issued and I filed the return also. But now again they are going to receive 148AB. So you have to wait and watch, sir. One more circular, whatever department we are waiting for one more instruction. Whether you need to file again return. Whether it will be enabled in the portal, whether it will allow me to file the return. These are the matters we discussed with the Principal Chief Commissioner of Income Tax, Karnataka, Goa. And he was apprised of this matter and they are in discussion with the board now. These questions were raised similarly. How to, whether how will this functionality be enabled on the portal? Very good question. There is no answer as of today.
Again, Virag is asking, notice under section 148 dated 12th April is required for AY 1617. ITR is filed. Reason are received and income escape as per ITR is 7 lakh. These notices were issued after obtaining permission of JCIT range. Objection is raised that notice is void since the approval of PCIT was necessary since 4 years have expired on 12th April.
Objections. All this put in your objections. Please put all this in your objections, sir. And don't immediately reply. Give him the time. Suppose 30 days are there and see what the Supreme Court has told. 30 days from today, from 4th of May till 2nd of June, I've got time. 30 days from today, I will give you the material and I will give you the information. You file your objections. Let that 30 days get over. He's giving me 14 days time. So after that 30 days over, within that 14 days, let me file this reply. So that assessing officer cannot again issue a notice here. Because you wouldn't have taken that approval letter, as you rightly pointed out, it is under the old regime. So let us see. All these objections are careful. Yes, sir.
So Suresh Kumar Jain is asking, notice under section 148A is received as there is difference in bank transaction and the assessee filed the reply stating that the difference in bank transaction is not correct along with bank statement. Still the AO is issued notice under section 148 of the IT Act. Now I have filed petition under section 144 of the IT Act.
No. What petition under 144? What 144, sir, petition? No, you have received 144 AD. No. You have received 148 AD order and 148 return. You filed in response to 148. You filed the return. Question is, sir, there is no question of petition in 144. You have filed petition in 264, I think. You have filed petition in 264 before the Principal Commissioner of Income Tax. So anyway, don't worry, that fellow Principal Commissioner of Income Tax, he is going to reject your petition. Once you reject that petition, you file a writ. Only thing you have is writ. Either you are, by mistake, you are telling 144A, instruction to Joint Commissioner. Earlier section, 144A, instruction to Joint Commissioner. Now that is redundant, sir, because of the faceless regime. So nobody is going to bother that. And if you file 264, 100% the PCID is bound to reject it. Once you reject it, you file a writ.
Yes, sir. 154 of the Act. Suresh ji is replying.
154 way of file, sir. 154, it's not a mistake apparent on record, no? They are going to reject it.
Yes, sir.
Yes, sir.
Sir, next question is from Ashok ji Dalmia. Sir, I would like to know the validity of notice issued after 31st March 2020 for assessment year 13-14. In light of Relaxation Amendment Act of 2020, can the notice issued after 1/4/20 for assessment year 13-14 challenge for its legal validity in spite of relaxation law?
Definitely, sir, we have to challenge it. Just wait for October 22nd. October 22nd, our Ajay Vora sir is arguing in Bombay High Court based on 15-16, based on this 149 time limit. Wait for October 22nd. You have to wait now. These High Courts are going to take up the matter of 149. Once the High Court again decide that 149 time limit, then things will be clear. Till that, you have to keep on objecting. That's all.
Okay, sir. Sir, Mukunji is asking, if I sell the house for 75 lakhs in May 2022 and book the larger house in June 23, do I need to pay tax on whole 75 lakh by 31st March 2023?
Come again, sir.
Well, there, sir, I think the question is incomplete and it's, I think, not relevant for this. Sir, Mansi ji is asking, in case of transfer pricing, is applicable, will the timeline extended by 1 year?
Yeah. Normally, sir, that 9 months, yeah, definitely. 153.2, what is she telling is it will normally extended time limit for passing order. 153 subsection 1 is time limit for passing order 143 or 144. 153 subsection 2 is time limit for passing order 147. So she is right, the time limit for transferring will be extended.
Okay. Sir, Ashok ji is again asking, how can the date be extended beyond 6 years in a case where the info was that with the Department of Property Sale in January 2013 and return was not filed for assessment year 13-14 via the registrar and department did not issue notice for 6 years. Can it take protection of TOLA and issue notice in February 2021?
February 21, sir. Now be careful. Now we are not between 1st of April to 30th June 21. February 21, definitely they can issue because of TOLA and because Finance Act 21 was not there, in my opinion. Because Finance Act 21 was not there at the time. So there it may be difficult for you. Anyway, you have to file your objections.
So Mukunji is asking, since the government had declared 30% tax on crypto, can we start dealing with cryptocurrency notifying the profit in books?
Definitely, sir. You have to show it. Please offer to tax.
Anil ji is asking. Yes, sir.
Yeah. Virtual digital asset. That VDA amendment has come. Correct.
So Anil ji is asking, respected sir, for AY 1617, TOLA cannot be applied and notice is not valid. In fact, the instruction by CBDT is incorrect.
Correct. 100%. I agree with you.
Bhupendra ji is asking, sir, the IT authority issued notice under section 148 after passing order under section 148A for the assessment of 1516. The IT website after the Supreme Court decision has removed the notice under section 148. Whether the assess is required to comply with the notice under section 148.
Acha, that 148 AD has now been removed online?
Maybe, sir, in that assessee, that no particular notice, I think, removed.
No. What is it telling? Which notice is removed? 148 AD or 148 itself is removed?
Sir, the IT website after the Supreme Court decision has removed the notice under section 148.
Okay, then you have to wait, sir, whether they are going to, is it more than 50 lakhs means you are going to receive a notice now. Based on department board instruction, I'm telling you. So this is the answer, sir. This may be the answer. All old notices they may now remove because they are telling 148 AB. All old 148 notices shall be deemed to be notices on 148 AB, giving meaning to say show cause to the assessee. So as the answer now, they have given the answer himself that all 148 notice will be removed there. Online, nothing will be available. No fresh notice will come under 148.
Sir, we have an appreciation from Rishi Agarwal ji. Thank you, sir, yes, for this wonderful session.
Thank you, sir. Thank you very much for your kind words.
Sir, can we take few more questions? Is that fine, sir?
Absolutely, sir. I have no problem.
Anil ji is asking, please explain third and fourth proviso of section 149(1) with few examples.
Sir, third and fourth proviso, I'll tell you. Now, for example, you have received 148 AB today. Let us take an example in your client's case. Tomorrow you are going to receive 148 AB. Okay. So minimum time anyway as per the section is 7 days. Maximum is 30 days. And based on an application by the assessee, it could be further extended subject to satisfaction of the assessing officer. That is the act. Supreme Court is telling when I issue that 148 shall be deemed to be 148 AB, within 30 days, I will give you all the information material. And within 14 days time, you get back to me. And then, I will convert it into, I will pass an order 148 AD. In the intervening period, suppose you have received that order under 148 AD, that it is a fit case for assessment. Okay. So assessing officer gave you 14 days time. Within 30 days, say within 30 days, he gave you the material, etc. information. Within 14 days, you also filed your reply. And he also, passed an order 148 AD. He told, no, this is a fit case for issue of assessment. Very good. So when you receive the order on 148 AD, you were advised, you are now filed a writ petition in High Court. And you got a stay. You got a stay 148 AD. So that stay is there. What the High Court will tell, it gives the stay for some period. And then it will take up the case on merits. So that period, injunction or the period of stay, that period will not be counted, they are telling, for issue of notice under 148. So whatever that period is there, suppose it is less than 7 days, next proviso is telling minimum 7 days should be given to the assessing officer to issue notice under 148. That is all is the third and fourth proviso.
Right, sir.
Okay,
Sir, Anilji again asking one question. Is conducting inquiry under section 148A subclause A is mandatory?
Sir, I gave you my opinion. It's only my opinion. It is compulsory and mandatory in all other cases other than search and survey and that 153C type cases. They have to do that inquiry actually.
Right, sir.
Because the assessing officer shall, it says, then it says under 148A if required. Now this is a provision. Why I am telling you, sir? This is a provision which is not yet tested before the courts. So when we go before the court, when I go before the tribunal, when I go before the High Court, at that time we are going to discuss this. And then the court will decide, yes, this is the interpretation of this provision.
Right, sir. Sir, Atulji is asking, if notice is issued post June 2021, can this Honorable Supreme Court judgment will apply?
Post June 21. Now the board notification, Supreme Court is telling 30 days from today only for the 90,000 notices. It is only giving 30 days time. It becomes an invalid notice itself. You did not even act upon that notice. Because within 30 days, Supreme Court has told, that is by 2nd June, you give all the information, material, etc. Notice can be issued, sir, no doubt about it. Because within 30 days, they are going to give you the material. Next 14 days, you have to, reply. And then they are going to issue the order under 148 AD along with 148.
No, please, in this, the queries, I think he is asking about the notice has been issued after 30th June 2021. Whether Supreme Court judgment will apply.
No, sir, not possible. In my opinion,
so
not
the
possible.
judgment is, see, the provisions of section 149 will only be applicable. The Supreme Court judgment is only relevant for these 3 months. April,
Correct.
May, June 21.
Yes, sir. Yes, sir. Yes, sir. I agree with Rajesh Bhai, sir. Yes, sir.
Sir, am I audible now, sir?
Yes,
sir,
yes,
please.
Yes, sir. Sir, then that Rakesh is asking notice under section 148A(b) received for AY 1314, and in reason the assessing officer mentioned that they are transaction with broker amounting to rupees 26 lakhs. Whether this is valid?
Sir, see, we have to object them whether it's information suggesting income as escaped assessment and whether it's only 2 types of information. That is your C and AG as well as flagged by RMS. That's all. So you have to keep objecting. Where is it? It may be information, but the words are information suggesting income as escaped assessment. So it is for the assessing officer to take a stand. It is for the assessee to file the objections.
Right, sir. So one more question. In my one of the client, notice under section 148A was issued before 31st March, that is on 21st March, and given 7 days for reply. And notice under section 148 issued after 31st March, that is on 5th April 2022. Can AO issue 148 after 31st March for AY 1516?
After 31st March 22. Is it
Yes, sir.
31st?
31st March 22, 5th April 2022.
I gave you my opinion, sir. Now I have already given you. That is my personal opinion, but it is only my personal opinion. But board instruction is telling clearly beyond 3 years up to 10 years, you can issue. Suppose the income escaping assessment is in the form of an asset and it is more than 50 lakhs.
Right, sir. Sir, Narvekarji is asking, sir, what is your opinion about invocation of Article 142 by Honorable Supreme Court is really unwanted in such matters?
Sir, we cannot comment on the Supreme Court because, I have just given you what is 142.1, in what situations it was used, and what is the limitation based on 142. See, because the Supreme Court, they would have realized the, the pendency. The Honorable Additional Solicitor General Venkatramanji briefed the Supreme Court saying that there are 90,000 notices and 9,000 writs. So that 9,000 writs, Supreme Court would have taken a stand. Lot of duplication, a lot of multiplicity, lot of duplication, lot of litigation, and then 9,000 notices. They understood the veracity there. Therefore, the judgment was passed in record time, because they knew, because already when 9,000 writs are filed, what about the balance 81,000 notices then? So therefore, they themselves are telling, in order to strike a balance between the revenue and between the rights and the duties of the SSC and the department revenue, we are invoking Article 121 for the cause of justice.
All right, sir. So, sir is asking that, so don't you feel that Honorable Supreme Court has set a wrong precedent by stating it bona fide mistake of AO and validating the invalid notices by deeming fiction?
I am telling you, sir, now every time the AO for this genuine bona fide mistake, this will become the case law to go to. They are going to raise the Supreme Court issue. Nothing stops the assessing officer from raising this issue now, because they have this Supreme Court judgment which is partly in their favor, and they are going to raise this issue now. For all bona fide, whether bona fide mistake or whether it is not a bona fide mistake, they are going to take shelter under this case law. And this is the law of the land.
Right, sir. Sir, Atulji is asking, cash deposit in bank account will be considered as an asset without considering the withdrawals.
Sir, we have to explain. That's what, sir, we have to explain our case, make out the case. Department is going to add back all the cash deposits. Let them add. So it is not going to sustain that. See, why they are doing this? Basically, all the cash deposits in bank, they are unnecessarily going to invoke Section 69 or 69A. Section 68 is cash credits. 69 is unexplained investment. 69A and B is partly disclosed, etc. Your money, bullion, jewelry, etc. C is unexplained expenditure, etc. Unnecessary addition will be made, and 60% will be the rate of tax. You factor in the surcharge, factor in the education cess, etc. It go as high as 78%. So unnecessary addition is made, and then board settle with that. Then you are telling me to pay 20% of the tax. So therefore, I think there the SSC will be aggrieved, and you need to file a writ petition if and at all you are sure that on merits there is a source. You have the source for all the cash deposits in bank. Go ahead and file a writ against 148 AD. Go ahead. There is nothing which stops you.
Yes, sir.
Fine, sir.
Sir, sir is telling, sir, thank you, sir, for an excellent session.
Thank you, sir, for your kind words.
CA Harit Khariwal, sir, is also, sir, excellent session, sir.
Thank you, Harit.
So, sir, with this, I mean, we have covered almost all the question, but still it is coming, sir. Last two questions will take, sir. What we received till now. Please, would like to request everyone to now stop asking. I think we are already running out of time at 7:20.
See, the problem here is I can only give my opinions, because this is a new provision yet to be tested before the courts. Now it is going to cause more and more litigation. That I am for sure it is, because post the Supreme Court judgment, post the budget notification, post the board instruction. Now how we analyze, how department analyzes, how we analyze, and how the courts are going to analyze. There are going to be three types of analysis now. First, your chartered accountant or otherwise analysis, department's analysis. Ultimately, courts will have to decide. So there is no final answer. Let me tell you, all the learned members, your view is as just good as my view. Your guess is as good as my guess. That's all.
Sir, Rakesh ji is asking the reason provided in response to objection under section 148 for AY 1314 but now the reason provided under section 148A in response Supreme Court are different reason. There is mistake in cut and paste of the reason under section 148A, and these reason are not related to us. Please suggest what we should. Simply, there are no transaction with the person as mentioned in notice.
Wonderful, sir. File a detailed objection, and then the assessing officer, if he feels definitely he has the power also to drop it. Suppose he is convinced, he may drop the case under 148AD. If he does not drop, please file a writ. Go ahead. The case will be closed in one hearing itself. Writ. But I think the assessing officer may, because you are telling you have never had any transaction with this person. So if you are able to prove based on all the documents and records, he may drop the case also. If not, you have a very fit case for a writ.
Right, sir. Sir, Kaushik ji is telling that we cannot take that shelter of bona fide mistake by assessee in other cases following this Supreme Court judgment.
Not at all, sir. Not at all possible.
Anil ji is telling, respected sir, in case of AY 1617, AO is trying to reopen the case on the basis of search conducted on someone else before 1st April 2021. So is it valid in terms of time limit of 3 years, and if yes, it is still valid as search is before 1st April 2021 and not after? I think, sorry, I missed to mention this amount in income is less than 50 lakh that cannot be opened.
Correct.
Sir, we have comments from members waiting for more session in future, sir. Thanks a lot. Sir, please share the presentation.
One more instruction come. Another week's time, one more instruction is going to come. It will create more problems. Wait for a month or so. You will have definitely some more writ petitions. Some more, it will give rise to more and more litigation. We can definitely, by the time October comes, definitely would have a High Court judgment on 149, which will make things clear.
Right, sir.
Thank you very much, sir.
Sir, members are asking, sir, that please share the presentation, as the same is very well articulate and very informative, and it contains all the details at one place.
I will have it mailed. Don't worry.
Thank you, sir. I would like to request now Rajesh Mehta, sir, for concluding remarks, and also for vote of thanks for Naveen, sir. Over to you, Rajesh.
Thank you, Naveen Khariwal, sir, for such a wonderful deliberation on such an important topic. And you have covered everything. You have covered detailed manner the Supreme Court judgment, CBDT instructions, the provisions prevailing in the Finance Act 2021, 2022, and the erstwhile provision. And in a very detailed manner, you have clarified that all the persons who have received any 148 notices or 148A notices, they should always file an objection so that their case can be strong in future. So they should not accept any notice as it is. So this is advisable. Your advice is very good, and everything has been discussed in a very detailed manner and very limited time. You have covered everything. And congratulations to Virag Bhai for organizing this wonderful webinar and inviting such a great speaker on this platform. So, and thanks to all the participants for interactive session. They have raised good queries also. So thank you all.
Thank you all the attendees for making as a very interactive session. Generally in webinar, we have seen that it's always one-sided, but we at ConnectVisit always strive for that interactive session and making asking your question on behalf of all the attendees to the speaker. And we are very thankful to Naveen sir. Sir has answered all the questions asked in the webinar, and there is I think there is no unanswered question, or there is very minimum unanswered question left out. So we are very thankful to Naveen sir for patiently answering all the replies as well, sir. Thank you so much. Thank you, Rajesh sir, for all your time, sir, and always motivating us. Thank you, sir. With this, we are concluding our today's session, friends. We'll coming up with more session in future, and we'll inform you all in a time to come. Thank you so much.